Hi, everyone. This is Attorney Lilian with Lily Legal, and I am here today to have an immigration chat with you. I am, like I said, I'm Attorney Lilian with Lily Legal, and we do immigration law, and that's all we do here. And this immigration chat is your chance to ask me your questions. I'll always have a topic for us to go through and for you to learn something. But if you do have immigration questions, these are your opportunity to ask me your questions. If you are watching this on the replay and you have questions, please go ahead and put them in the comments. I do go back and I do respond to your questions, so feel free to do that as well. Okay, so if you have seen the topic of today, you will know we're talking about what you have to do, right? What you can actually do when an immigration officer decides that they're not going to approve your case, right? If they deny your case, what are your options? That's what we're going to be going through today. And that's what I really want us to talk about. So if you have any questions as I'm going through, as always, put your questions in the comments. And hi, Sa, welcome. And if you as always, there's some people that don't feel comfortable putting their questions in the comments. Feel free to send Lily Legal a DM and just put immigration chat on it. So that way I know to either talk about it in this video or in next week's immigration chat. Okay. So as always, let's get into this. That's our typical housekeeping announcements. Ask me your questions. That's what I'm here for. And we will get into the topic. So, like I said, the topic of today is what to do when an immigration officer denies your case. Okay. The options available to you depends on what application you're filing and where you are location wise, right? If you're in the US versus outside of the US, your options are different. So it's really important that when you're speaking with an immigration lawyer, that you are not only telling them what you applied for, but where you applied for it. Where was your case denied? Was it denied in the US or outside of the US? So I'll start with the most popular question people ask me, which is when it comes to the visiting visa. What can you actually do if you were denied at the embassy? So for anyone that doesn't know, when you're applying for a B2 visa to the US to come and visit for pleasure or medical reasons, you are going to the embassy for an interview. This is not done in the US. Okay, this is done at your consulate in your home country or in the country that you reside in. And typically, you go to the interview, the officer makes the decision whether to approve your case or not. Now, if the officer decides they are not going to approve your case, again, that's going to be based on a bunch of different factors. And if you have not, okay, I'm going to repeat this. If you are going to be applying for a visiting visa to the US and you have not watched my visiting visa immigration chat, you should do that before you apply, because we really want to make sure that you are putting your best foot forward when it comes to these applications. You don't want to do it more than once. That's one thing I can assure you. You don't want to do it more than once. You want to go in, you want to apply, you want to be approved, and you want to be done with it. Now, if you apply and you're not approved, what are your options? So unfortunately, with the visiting visa, your real option is to apply again. Okay. There's no limit. And this is a question that comes up. There's no limit on the amount of times that you can apply for a visiting visa. Okay. Now, every single time you apply, you have to make sure that you're consistent in your application. You're not changing any facts. Everything is The same unless, let's say the first time you applied, you were not married. And then the second time you're applying, between the first and second application, you got married. You should be updating your application to reflect that. Or between the first and second time you had a child, you should be updating your application to reflect that. Or for example, if you now have an amazing job that you didn't have before, you should be updating your application to reflect that. So you want, so for these visiting visas, if you get denied, your option again is to reapply, but not just reapply. Okay, you want your reapplication to be the best application you can possibly put out there. And the best way to do that is, one, if the officer tells you that they're going to deny your case, you should ask them why. I know it's so intimidating when you go into the interviews. I know it's easy for me. I'm a lawyer. I deal with this on a daily basis, right? But if you can have some courage and ask the officer what their reason for denying your application is, that will really help you when you're trying to reapply. Okay? Because the officer is not really required to give you an explanation. The embassy is different from USCIS in the US. Okay, if you've watched my previous videos on notice of intent to deny, you know that they're supposed to give, in the US, they give you a notice of intent to deny telling you why they want to deny your application. But when it comes to the visiting visas, they don't do that. And because they don't do that, you are now in a place where you either have to ask the officer before you leave the interview why they're not approving your case, or we have to guess. Okay, so if you can have the courage and ask the officer why they're not, why they feel that your application is not good enough to be approved at that moment, then when you finish the application, right, when the officer says we're denying your case, when you go to reapply, you know that the reason is probably the most common reason, right? It's probably that you don't have enough ties to your home country. You didn't provide enough evidence that you had ties to your home country. Okay, so if that's the reason, now we know that when you go to reapply, we have to really document every single way that you have ties to your home country. Okay, so this is why it matters so much what your next moves are after your application is denied. Okay, I've had people that apply, their case is denied, and they wait 2-3 years and reapply and they're approved, because in that 2 to 3 years they have established their careers, they have built a family, they now have sufficient ties that the officer is able to approve their case. So just because you were denied once for not having sufficient ties doesn't mean that once you have those ties, your case will be denied again. Okay, so if you are applying for a visa at the consulate, especially in non-immigrant visa, you should be really looking at why the officer is denying your case and making sure that when you go to reapply, that you are putting your best foot forward, that you are answering the officer's question, right? Whatever issue they have with your case, that you are solving it for them. They don't have to think about whether you have sufficient ties, because you have provided them copious amounts of documents, right, showing that you have sufficient ties. So that's really what you can do when your immigration, when an immigration officer denies your B2 visa application. Now, let's get to why some of you might be here. If you are in the US and you are applying for a green card and your case is denied, what is your options? Right? I know that's what some of you want to know. What are my options if my case is actually denied? So it depends on, I know it's such a lawyer answer, but it really depends. And it really depends on which applications are denied. So if you're filing for a green card through your spouse and your I-130, which is the application that your spouse is filing for you, is denied, you will know why it's denied. Typically, you will get the notice of intent to deny. You have the opportunity to respond, and then the officer makes the final decision of whether to approve it or deny it. Now, with that, you have the option, you have a couple options, right? You can either appeal the decision denying the I-130, or you can refile, which is basically starting over and presenting more documentation. Typically, when an I-130 is denied for spouses, is because the officer might not believe your marriage is real, or there might be some documentation issues going on. So if it's a documentation issue and you're able to fix the document and you now have the document ready to go, you might want to consider refiling. If it is an issue with the officer not thinking you have enough evidence of your relationship, again, you might want to consider refiling. Now, if the officer decides that decides that they believe that your marriage is fraud, right? That's different from saying that you don't have enough documentation of your marriage. But if the officer goes a step further and says that your marriage is fraud, in those situations, you might want to consider appealing, especially if you have enough documentation of your relationship. This is really something you would need to talk to your immigration lawyer about, because you don't want to make these decisions on your own, right? Because we have experience on what is enough documents, what can we appeal? Because appeals are based on, when appeals are done, the BIA, which is the appellate division that deals with immigration appeals, look at what they have decided in the past, right? There's precedents coming from the Supreme Court, there's the law, there's a lot going on that you need to be aware of before you file an appeal. So that's why when it comes to that, I typically suggest that people do not do that on their own, because there's so much going on with that. And if your appeal is denied, you might just have to start over anyway. So you really want to meet with an immigration lawyer and basically present your facts and documentation, and they can advise you on the best option for you. Again, this is for informational purposes. I'm telling you what options are out there. I cannot tell you what options will work in your situation because I don't know your specific facts. Okay, so it's really important that I put that out there, is that even though I'm telling you what you can do, it doesn't mean that every single thing that I'm suggesting is going to work in your situation, because I don't know what's going on in your particular case. Okay, so now you can, like I said, for marriage-based ones, you can either file an appeal of the I-130 if it was denied, or you can refile. If it was denied for something minor that you can easily, sometimes you can file a motion to reconsider, which is basically asking USCIS, hey, you guys made this decision, but look at this evidence that wasn't available before that we think will change your mind. Okay? If their minds are not changed, your option is still that appeal, right? And remember, you're paying for the motion to reconsider and you're paying for the appeal. So when I say that in some situations, your best bet might just be to reapply. Unfortunately, I know people hate starting over, but in some situations, your best option might just be to reapply, because in a reapplication, you are getting another interview. Okay. With an appeal or a motion to reconsider, you're not really getting another interview. They're just basing it on the documentation and the evidence that you already presented. And if your evidence is not strong, it might be best for you to start over and present more documents. So typically what happens is people get married, they start a bank account, they haven't really had the opportunity to use it that much, and they file. By the interview, they might not even have that much going on jointly, but they've been building it over time. So if you reapply, that means you're giving yourself more opportunities to have more documentation to present. Okay. So there is, you have options available to you. That's basically what I'm trying to say. If your case is denied, you have options available to you. So it's really important that you pay attention to when you receive the notice, what dates on the notice, and all of that, because here's the thing with USCIS denials, there's a time limit. Okay. If you're going to appeal, there's a time limit. If you're going to file a motion to reconsider or a motion to reopen or any of that, there's a time limit. And that time limit is typically 30 days. And not 30 days from the date that you receive the notice. No, it's 30 days from the date on the notice. So when you get your letter, your denial letter, on top, right? On the top left-hand side, you will see a date. That's the date that you need to focus on, not the date that your mail guy dropped the letter in your mailbox. That date does not matter. The only date that matters in this situation is the date on that top left-hand side of the letter. And if that notice, and once you receive the notice, you really have to move quickly if you want to file an appeal, or if you want to file a motion to reconsider or a motion to reopen, because you really want to give yourself as much time as possible to meet with an immigration lawyer to start to figure out your strategy, to figure out what's best for you in your situation, and what documentation or how much time the lawyer might need to even file the motion or the appeal. So you really want to give yourself as much room as possible. So remember, if you are applying through your spouse to get a green card in the US, right? If your case is denied, your option, typically the I-130 is what's being denied. And if the I-130 is what's being denied, you have the option to appeal or file a motion to reconsider. Or your third option is to start over and refile the application. Your option, the one that will work best for you, really depends on your particular facts of your case. Okay? Now, let's say the officer decides, oh, your marriage is real. We're going to approve the I-130, but the green card application, we're not going to approve that because of, let's say, because of misrepresentation or because of fraud, because you had a criminal history, something, right? If there's a reason that your green card application cannot be approved, not the I-130, but the 485, if that is what's being denied, then you have the option to file a motion to reconsider or a motion to reopen. There's not really an appeal process for that. So it's really asking them to reconsider their decision. Now, if it's denied because of a misrepresentation or fraud, remember, we did a whole immigration chat on waivers, right? You might qualify for a waiver for whatever misrepresentation or fraud that they're saying that you committed. So again, reach out, let's see what the situation is and what you qualify for, because that's really what's going to matter. If we don't know what you qualify for, you might miss a deadline to file the motion. Again, remember, motions to reconsider, motions to reopen are 30 days from when the notice is sent, right? When the letter that you receive says, the date on that letter, 30 days from the date on the letter, not the date that you received it. So you really want to know why it's being denied. And if it's something that you can file a waiver for, please go ahead and watch my waiver video just to see what types of waivers may be available and what you would need to basically get a waiver approved. So in those situations, again, if it's something that there's a waiver, typically you would either file the you would refile, right? If you think that yes, there might have been misrepresentation, or there was a misunderstanding, but fine, let's say it was misrepresentation. Your options, your realistic option is to refile the green card application with the waiver, right? Because now you're saying, hey, I hear you, USCIS, right? You didn't approve my green card because you said I had a misrepresentation. Well, here's my green card application with the waiver. Now, if you approve the waiver, you should be able to approve the green card. That's how these things work. Okay. So if it's something that's waivable, go ahead, talk to a lawyer, see what the waiver that's available to you is. And if there's a waiver available, start the process of getting the documentations together and working on the waiver. Okay, because that's what's going to lead to USCIS being able to approve your case. If they have decided that you need a waiver, right? You weren't able to convince them that you don't need a waiver. They have firmly decided that you need a waiver. They are not able to approve your case until they get that waiver approval notice. So it's really important that you understand how these things work together and how it's not just how it works together, but how you can use the information you have received, especially if you got a notice of intent to deny before the denial. Now you have a whole playbook of the reasons that they want to deny your case. When you reapply, now you are able to basically every single point that they said is wrong with your case. Reapplying will give you the opportunity to basically, oh, you said that we didn't live together and I didn't provide proof. Well, here's the proof that we lived together. Here's the proof that we had joint bank accounts. Here's the proof that my job has my spouse as my emergency contact person. You can really go through and have those things in there so that when the officer is looking at your case and they look at the denial, they can see that, oh, we may have made a mistake here. We might be able to approve this case after all. Okay, so that's really what you're trying to avoid. Now, there are situations where refiling is not an option. Okay, and I'll tell you what those situations are. If you file through a spouse and you two are no longer in a marital relationship and they want nothing to do with the case, they're willing to file an appeal, but they're not willing to go through another interview or deal with that whole mess, right? Then an appeal of the I-130 might be your best bet in order to get the case approved. Okay. There are situations where the spouse may, right? If the US citizen or permanent resident spouse withdraws the application. So this is not a denial. They're sending a message, a letter to USCIS saying they don't want to move forward with the case. They want to take back their application. There is no appeal. There is no motion. There's really nothing you can do to revive that application. So once they withdraw it, the case is basically done for the most part. Okay. The I-130, if it's not approved yet and it's withdrawn, that's it. You can't appeal the decision to withdraw it because the petitioner is the one that asked for the petition to be withdrawn. Okay. There are options available to spouses that are victims of domestic violence. I have a whole video on that, several videos on VAWA and how that can be a path to freedom for some people. But I just wanted to hit on that point because it's something that people do ask. And I want to make sure that I'm addressing your questions. Again, if you are just joining me, feel free to put your questions in the comments. I am here every Friday at 12 o'clock Eastern Standard Time to basically answer your questions and educate you on an immigration topic. Whether you're watching on Facebook, on my personal Lily Legal Facebook page, on Peace TV, thank you again, and or on my YouTube channel, you are able to ask me your questions and I will respond to you. So even if you're watching this back later, even if you're not watching this live, feel free to ask me your questions. Okay. Put them in the comments. I will go back and respond to you. If you are not, if you are shy and don't want to put your questions in the comments, feel free to send me a DM and just put immigration chat on it, and I will address that on next week's video. So if you have a question, message me with the tag immigration chat, and I will, if I see it while I'm live, I will respond live. But if I don't see it while I'm live, I will respond in the next live video. Okay, so as always, let's continue. Okay, so we've talked about what to do if your visiting visa is denied, what to do if your marriage case is denied. Now, let's talk about what you can do if your marriage-based case in the US, like you, the non-citizen, the foreign national, you are in the US and your application is denied, what you can do. Now, let's talk about if you are outside of the US and your application is denied and it's based on marriage, what you can do. Okay, so there's a bunch of different things that comes up with this. So if it's the I-130, right, if the officer believes that your marriage is not real, then they are going to send the application back to the National Visa Center in the US and basically have them send you a notice of intent to deny, saying notice of intent to revoke, because at this point your I-130 has been approved before it gets to the embassy. The embassy can now decide to revoke the approval because they don't believe your marriage is real. Typically, like I said last week, this happens at the interview. Something goes wrong in the interview, and now you have to try to fix the case. If you're not able to get a notice of intent to revoke withdrawn and sent back to the embassy, you are basically left with the option to either appeal or you can go ahead and refile. Again, there is cost involved with both options. I always say this because when you appeal or when you file a motion, there is cost involved. That's just what it is. When you refile, there are costs involved, and there's also time involved in both options. Refiling, you might have more of a predictable timeline than an appeal. Okay, so it's really dependent on what your strategy is and what will work best for you, your spouse, and your family. Okay. When I have these meetings with my clients, I do not just think of the individual, I think about the whole unit, right? The person wants to be with their spouse and their children. If they have children in the US, they want to figure out what's the best way, what's the fastest way, what's going to give me the best result if I am outside of the US and my spouse and children are in the US, because I don't want to spend more time away from them or go ahead and file something and it not be approved and I have to start over anyway. So it's really important that when I'm meeting with people in these situations, we really dive deep to figure out what is your goal, right? Not just, oh, of course you want a green card, but your options will depend on how long you're willing to wait, right, for that green card. If you're willing to do an appeal, which if it gets denied, you might have to start over. So it's really important to, for me, it's really important to have these conversations about where people are in their stage of life and with their family, so that I know that the decision or the recommendation that I'm making will actually work for them and their family. Okay. So when you're thinking about this, when you're presenting your um, case to a lawyer, just know you are you should be talking about what's important to you, not just, oh, I want to get my green card, but what's the best way, right? What would work best for you and your family? If spending another year, if it's predictable that you might be able to spend a year or two outside, and based on what documentation, your case might be approved the second time around, that might be a better option. But for someone that's not, that wants to take the chance of an appeal because of their own personal reasons, that might be a best option for them. So everyone's best option is really dependent on their specific facts. So I want to make that very clear. This is not me telling you that you have to refile or that you have to file an appeal or you have to file a motion. That's not what this video is about. This is about me explaining what the different options are, what you can actually do, and how it can affect your case, depending on the option you take. Okay. So if you're outside of the US and your I-130 is revoked, like I said, your spouse can file an appeal and try to get that overturned so that you can get back to having another interview and potentially getting your green card and coming to the US. Your other option, with every single thing I have said, your option, you always have the option to refile. Always have the option to refile. Like I said before, there's no like limit on how many applications you can file. But the key is knowing why the previous applications were denied. That's really the key for you if you decide to refile, is why was the previous application denied and how can I present documents and evidence to show that I can overcome all of those reasons, right? That I can now show every single thing an immigration officer wants to see in my case. How can I do that? And that's the key to a successful refile. That really is, because you don't want to send in the same documents and do the same exact thing you did the last time, and your case might end up in the same situation of being denied. Okay, so you really want to, if you're choosing to refile, you need to look at your case. You need to look at why it was denied, and you need to make sure that when you are reapplying, you are presenting documents and evidence that goes to every single issue the officer had about your case. If you are not resolving those issues for the officer, you might just end up in the same situation again. So that's why I will always tell you and, you know, advocate that if you are not sure, if you are not sure what your next steps should be, what you can legally do, what options are available to you, reach out. I am happy to meet with you and look at your case and figure out what your options are and what will get you a better result. Okay? So, again, always reach out to an immigration lawyer when you are not sure what your next steps should be. Our job is to help you on your immigration journey and get you to your final destination. Okay, but if we are getting there, if you're bringing us in after, you know, you already had a crash, it's really hard to get everything back on the right track. Okay, but it's important that if you are at a dead end with your application being denied, that you reach out so that we can help you figure out the best way to get you back on track. Okay. And some situations, like I said, some situations, a motion to reopen or an appeal might be the best option for you. I've had situations where that was the best option for my clients, and that's what we went with. And I've had situations where refiling and actually answering every single issue the officer had in the case was the best option for my client. And that's exactly what we did. And again, if you give the officers what they want, they're more likely to approve your case. And that's why, you know, if you take nothing else out of this live, it's figure out what the officer wants, right? Because when they deny your case, they're telling you what they didn't get from your application. What's the issue that they have with your application? Now it's your job to figure out, okay, they said X and the solution is Y. So let me provide Y the next time around. It's really important that you give the officer what they're asking for if you're going to refile. If you're filing an appeal, you're basically saying, right? The point of an appeal is that you're saying that you presented enough documents, right? I have shown you that my marriage is real, and you are picking on the little things that don't really matter. That shouldn't be the reason that you deny my case. And you are basically asking the Board of Immigration Appeals to decide in your favor that USCIS messed up. They didn't know what they were talking about when they decided to deny your case. They focused on the wrong things. Now, your case has to be strong, your documentation has to be strong for you to make a successful argument when it comes to an appeal. And like I said, in some situations, your only option might be to appeal, but you wouldn't know that until I can't tell you that without knowing your particular case. So when you're appealing, you're saying, here's my evidence, USCIS messed up. Here's why they messed up. Here's the law that shows that this is not how they were supposed to weigh the facts, right? This is the case that you decided before that showed that my case is similar, and they should have ruled in my favor just like you did on this case, right? Or the Supreme Court decided, on this case, and therefore mine is similar to that, so so you should approve mine. That's what an appeal is basically saying. You're presenting facts, you're presenting law, you're saying there was a mistake that USCIS made in applying the law to your facts, right? And if that's the situation, the Board of Immigration Appeals can go ahead and approve your appeal, and you can then, your application is now back alive and you can get a green card. Now, if it's still denied when you file the appeal, you have the option to appeal that to an actual district court. So that's outside of the immigration system. Now you're going into a regular courthouse, not an immigration court, and saying that what the immigration um, system decided on your case is not valid, and look at the law, look at the facts. Clearly, they made a mistake. And now the district court is going to be making those decisions, and you can basically appeal up to the Supreme Court, depending again on the facts of your case and how much money you have to dedicate to your case. If you are able to refile, you have the option as well. So it's your case being denied doesn't mean that your whole immigration journey is over. It just means that you need to recalculate, right? You need to reevaluate what's going on in your particular situation and figure out what your next move should be, right? What will help you get back on track? That's what you need to figure out if your case is denied. In some situations, I would, so I'm trying to figure out the best way to word this. In some situations, I would tell the person straight up, refile, right? Especially if it's a lack of document or discretion, right? If it's a discretion issue, some of those things are not appealable. So if the officer's like, based on my discretion, I'm not going to approve this, it's hard to argue against that unless you really have, again, it depends on your facts, right? If your facts is enough that you can appeal that decision as that is arbitrary, like they had no basis to make the decision, you might have a shot at getting that decision overturned. And there's situations that people have chosen to go that route, and then there's situations that people have chosen to refile. It really, like I keep saying, it depends on you, on where you are in your immigration journey and what you're willing to do. Right? If I have a client in my office and they don't want to appeal, or they insist on appealing and not a refile, I will be looking at their situation. I'll be looking at the documents, everything, to decide if that's the best option for them. All I can do is give you the facts as I see it. And if I don't think you have a strong appeal, I'm going to tell you. And that's that's something that my clients will always get from me, is that I will tell you the truth. Now, if you want to continue on the path that if you disagree with me, that's fine. We're allowed to disagree with each other, but you will always get the truth from me. And that's something that, I think my clients appreciate, is that when something is going on in their case, or when I see documents that don't make sense or anything of that sort, I will stop and I will point it out and I will tell you what could happen by you doing this, or by, so if you file, so for example, if you file an application and you include a divorce decree, and I'm looking at the divorce decree and it is from the wrong court, or you and your spouse were not in the country where the divorce was done, I'm telling you right then and there that your case that you will have issues if you don't get the divorce fixed. So this is before we even file. I'm being honest with you. And yes, it's going to take you longer to start the process because now you have to fix the divorce issue. But do you want to fix the divorce issue before you get it before USCIS? Or do you want to get it before USCIS, have them tell you that your divorce is not valid, making your marriage not valid, and basically You might have to start the whole thing over. My job is to make sure that you don't get to that point where your case is denied, but that part of that is telling you the truth and hopefully you listening, right? So again, just a quick recap before we get out of here, okay? And you get back to your Friday and weekend. First thing, if you filed a visiting visa application and it was denied, you have the option to refile. Have the courage to ask the officer why they denied your case. If the officer is gracious enough to tell you, make a note of it and make sure that when you refile, that you are basically presenting evidence that makes the officer feel comfortable approving your case a second time around. If you are in the US and you're filing for a spouse and your spouse is also in the US, if your I-130 is denied, you have the option to appeal. You have the option to file a motion to reconsider, right? And you have the option to refile the application. If your green card application, the 485, is denied, you have the option to file a motion to reconsider or a motion to reopen, again, depending on your facts. And you have the option to refile. If you are outside of the US and your spouse is filing for you and the I-130 is denied, again, you have the option to appeal and file a motion to reconsider. If the I-130 is approved and valid and it's your actual application, the green card part, that's denied. We need to know the reason it was denied. If it's something that can be waived, you can reapply with a waiver. And that way, you'll be able to apply and get the green card. If you're outside of the US and your green card is refused, some of the times they will let you know that you have the option to apply for a waiver. You can apply for the waiver while, even though your case is refused, it's refused because you don't have the waiver. Once you get the waiver approved, your case will most likely be reopened and you can get the green card because now you have an approved waiver and it takes care of the reason the officer was planning on denying your case in the first place. Okay, so those are your options and basically what to do when an immigration officer denies your case. So I hope you find that helpful. If you did, please do like, share, and if you're watching this on YouTube, go ahead and subscribe so you can catch all my videos. And if you are watching this on Facebook, also go over to YouTube and subscribe so that you can get the bonus videos that I do over there as well. Again, I want to thank you for joining me today, and I will see you next week for more Immigration Live. And if you want to have a personal consultation with me, feel free to do so. My information will be in the description. And of course, you can always call my office, and the number is right on the screen. So thank you so much, and I will see you next week. Bye for now.